Okay, so we're going to start our discussion of Chapter 9, which is agency formation and duties, with the dissection of a case. All right, and I think this case does a good job of detailing the essential elements of an employee-employer relationship and or an employer-employee relationship and an employer-independent contractor relationship. Okay, so the case is Coker versus Pershad, and this case is in New Jersey Supreme Court. I'm sorry, the New Jersey Appellate Court. Facts of the case: motorist is in an accident, calls AAA to dispatch a tow truck. Um, AAA contacts an agency which it has a contractual relationship, Five Star Auto, to provide towing service. Five Star does in fact send a tow truck with the driver, Terrence Pershad, to the scene of the accident. All right. Now, some disagreement happens, and we don't have all of the facts as to how this escalates, and we really don't need them. Although there might be some entertainment value if we were to have that information. What we do have is by some semblance of events, by some chain of events, I should say, um, the tow truck driver, Terrence Pershard, gets into a fight with Nicholas Coker, who was not the driver of the vehicle, but he was the passenger in the car, and it ends with a knife assault. All right, so a knife is pulled, someone is threatened, um, and presumably injured. So those are the facts of the case, right? And quick review. Let me see if I can pull up the. It's not what I want. Um, Not really what I want either. I was looking for the laser pointer tool. Um, okay. So Coker versus Prashad. Quick review of 2081. I'm sorry, 2080, the legal environment of business. Coker's the plaintiff here. Prashad's the defendant. And in fact, let's go to the next slide. What we'll find is that Coker has actually sued. Um, Here we go. Um, Coker has actually sued not only Terrence Prashad, the tow truck driver, but also Five Star, the tow truck company, and AAA, who was called and dispatched the tow truck company. All right. So what's happened up to this point? Because we're reading an appellate decision, so you know from the legal environment that something's already happened at the trial level. All right. So at trial, the trial court decided that AAA could be removed from the case because its relationship was an independent contractor. All right. The court allowed the two other named defendants to be left in the case, Five Star Auto and Terrence Pershad. All right. And so that's really the issue here because uh, Coker appeals that ruling. All right, so presumably AAA was a better candidate, perhaps a deeper pocket than Five Star Auto. It could be Five Star Auto as a single tow truck company. I don't know this, I haven't researched it, but presumably AAA is a big company, right? So presumably it's a better pocket, a deeper pocket. It may be easier to collect from them, and that may be the reason that Coker appeals the decision that AAA should be removed from the case. All right. So that's really the issue on appeal. All right, which of the named defendants could be held liable for Coker's injuries? All right, so our rule of law. And these are the factors, and these are important factors. This is really the takeaway from this case to consider in determining whether an employer-employee relationship exists, or in the alternative, an employer-independent contractor relationship exists. All right, so let's look at these factors. The extent of control the employer exercises over the details of the work. All right. And so the idea is the higher level of control the employer exercises, the more likely it is that the relationship is going to be classified as an employee-employer relationship. Conversely, when the worker kind of decides how to get the job done on their own, that's a lesser level of control. That would be more likely to be indicative of an independent contractor relationship. All right. Second factor, whether one is employed in a distinct occupation or business. So, for example, in this case, if I am a tow truck driver, I may take calls that AAA calls me for, but chances are I'm in the phone book as well, and you can call me directly and have your car towed and perhaps get stabbed. Kind of a combo package, if you will. But anyway, I digress. When one is employed in a distinct business and has customers other than the employer, that leans toward being classified as an independent contractor. All right. Whereas when you really only have one employer, that would lean towards being classified as an employee. All right. Third factor, whether the work is done under the direction of the employer with or without supervision. All right. If I decide how to get the job done, perhaps I am, a professional, and I decide the best way to get the job done, I'm more likely to be an independent contractor. If I have a set of policies and procedures that detail how to do my job, i.e. an employee handbook, well, I'm more likely to be treated as an employee. All right. Fourth factor, the skill required for the particular occupation. More skilled labor. And again, these are factors, none of which is individually dispositive. It's more of a totality of the circumstance. But the fourth being the skill required for the particular occupation. So when something requires more skill, you're more likely to be treated as an independent contractor. For lesser skilled jobs and labor, you're more likely to be treated as an employee. All right. Whether the employer or the worker supplies the tools of the trade. This case is also a very good example for that. AAA dispatched 5-Star Auto. Well, 5-Star Auto showed up in their own tow truck, right? AAA didn't own the tow truck. The tools of the trade were provided by the 5-Star Auto, who alternatively, if AAA had dispatched their own tow truck to the situation, then that would lean more towards an employee relationship. The length of time for which the person is employed. All right. So generally what we're thinking about here is indefinite relationships. For example, I'm an employee. I work until either one, I'm terminated, or two, I quit. All right. That indefinite relationship leans towards employee-employer. It is common for independent contractors to have term relationships. right? So the agreement for between AAA and 5-Star Auto perhaps was for a period of a year or 2 years, for a period of time that AAA can contact 5-Star Auto with jobs, and of course there's compensation available. All right, so those are the 6 factors applied in determining whether a relationship is an employee-employer relationship or employer-independent contractor. So let's start with 2 general rules. All right, and this is why this decision is very important. Generally, employers are liable for the actions of their employees. Generally, employers are not liable for the actions of their independent contractors. And I've phrased those with generally because there are exceptions to both of these rules. One rule, you may remember from 2080, basic. I didn't put it on the slides because it's so basic, but maybe I should have. But individuals are always responsible for their own crimes and are torts. So that's relevant. We'll circle back to it in just a moment. All right. So the conclusion here, applying the factors, the appellate court held that 5-Star was an independent contractor of AAA. All right. And so hopefully you picked up on that as we were going through those factors. Therefore, AAA should not be liable in this case. All right. So I'll continue on in just a moment, but that is the appellate court agreeing with the actions of the trial court. That's what we call an affirmation. So the trial court has affirmed the decision of the lower court. Further, 5-Star was the employer of Pershad and could be held liable. All right, and this is not really a decision on liability, it's just potential liability, if that makes sense. So when the case goes forward, 5-Star is a named defendant and can be held liable, and Terrence Pershad pulled a knife, he can be held liable for his own actions, right? Because that's back to the rule that individuals are always responsible for their own torts and crimes. So the proper way for this court case to proceed is with the named defendants Terrence Pershad, the individual who pulled the knife on Coker, Nicholas Coker, and also 5-Star Auto, because 5-Star Auto had hired Terrence Pershad as an employee, right? So we went through those factors between AAA and 5-Star Auto. If we look back at those factors for Terrence Pershad and 5-Star, we're going to see that he's an employee, right? Because Terrence Pershad shows up in a tow truck that's owned by a 5-Star employee. So 5-Star is providing the tools of the trade to Terrence Pershad. 5-Star dictates, where and when Terrence shows up and does work, right? There's a good chance if I look in the phone book, I'm not going to be able to call Terrence to come tow my car, but I can call 5-Star Auto and they can dispatch Terrence in a truck, and presumably he would stab me. Okay, so for those reasons, the proper parties to be held liable are Terrence Pershad and 5-Star Auto. Okay, that's the law on employee, employer, and employee independent contractor.